Three. Okay, this is three.
Hey, this reason is off. You can't be that close to the finish. They're talking about. Thank you. Please be seated.
Good afternoon, Your Honor.
Good afternoon.
Your Honor, we're obviously here on some motions that have been filed this week in the state versus Richard Alexander Murdaugh. He, of course, is present in the courtroom here today with his counsel, Dick Arbulian and Jim Griffin, as well as Phil Barber and Maggie Fox. This, of course, is 2022 GS 15 592, 593, 594, and 595. And Your Honor, over, of course, the past couple of weeks, we've had a number of motions. We were actually, as Your Honor is aware, here last Friday in front of Your Honor, very briefly, where we discussed some jury questionnaire issues, and we provided to the court a general jury questionnaire for the clerk to do with the summons. And also at the time, I discussed with Mr. Harpootlian the admissibility of any financial evidence. And so they, of course, filed a bill of particulars on Monday. And of course, we discussed at the time us doing a response on Wednesday, which we did. And so obviously we're here to address that as well. The defense has also filed some motions as it relates to a particular forensic report. And I believe we're here to discuss things about that as well. Starting out, Your Honor, with the bill of particulars, and of course we filed.
Objection, Your Honor. We filed the other motion first. I'd like to deal with the blood spatter information first, which will be briefer, and then Mr. Griffin and Mr. Waters can go at it on the bill of particulars. But
We'll proceed with the motions in the order in which they were filed.
thank you. Your Honor, we filed a motion basically to have this court have an evidentiary hearing on the so-called blood spatter evidence. And I want to walk the court through what we've pieced together concerning how this was done. And let me say this.
Because I read the motion in which you,
We detailed that.
including, let's see, how many pages, it's 11 pages of detailing
Yes.
all of that.
I think it's important though, because when I asked for an evidentiary hearing, I want to emphasize a couple of things.
All right.
And I'm not going to walk you through the scientific tests that were conducted. What we do know is this, that on the night of the murder, they took from Mr. Murdaugh his shirt, his shorts, and his shoes. They ran a series of tests on those items and found a preliminary test indicated the presence of blood, and they cut out pieces and did DNA testing on those. There is some of the area which would become relevant in this blood spatter. It is clear, two things are clear. One is that one of those spots of blood spatter was negative for Paul Murdaugh's DNA. Number two, the test run by SWED, which we did not get until a couple, 3 weeks ago, indicated no presence of blood, of human blood, which if you're going to have somebody testify that there's blood spattered, I think part of that is there needs to be some blood. Now, critically,
Are you presuming that there will be testimony or the state will offer evidence of blood spatter, or you're?
yes, sir. I mean, well, I will say that the state has indicated they're pondering that based on the evidence we've come forward with and the difficulty, and I just want to make sure for the record it's clear that in the process of conducting these tests, SWED has destroyed the T-shirt for the purposes of examination. And the way we became aware of that, let me say this, I want to make this clear. In no way am I inferring any untoward, illegal, unethical, dishonest conduct on the part of the Attorney General. I don't want that in any way to be inferred. I think he got those blood tests, the results of the blood tests the same time we got them, and we probably wouldn't have gotten them had he not asked to get all the reports through the attorney for SWED rather than going through the normal route. Since the shirt has been destroyed, we went out and looked at it. We all, Mr. Zelenka, Mr. Waters, Mr. Barber, and I all went out and looked at it. And they could see it can't be tested again. We wanted, and what keyed that was us wanting microscopic and I'm not talking electron microscope, I'm just sort of, you could use a magnifying glass basically to get the kind of photographs we wanted, that kind of detail. They couldn't do it. They can't do it, never will be able to do it. So as we looked at this further, Your Honor, we've done something in this case that most defense attorneys aren't able to or don't do. It's something we do routinely in a civil case, and that is to take the discovery and put it in a database, which is searchable. And in my office, Holly Miller, this young lady right here, actually is a genius that knows. I mean, I couldn't find. Let me just say, make this clear for the record. I in no way take any credit for using a database to find anything. That's way beyond my capabilities. But she found in something that was labeled a memorandum of interview with Kenny Hughes, the draft report of Mr. Bevel, their expert, on blood spatter, in which he said there's no evidence of high velocity blood spatter. Not qualified. Now there's a PowerPoint that went with that apparently we haven't gotten, we've asked for. But he was unequivocal, no blood spatter. And blood spatter, high velocity blood spatter is created when you're near somebody and you shoot them and there's this sort of spray, a very, very small spray. So once we had that, we began asking questions and looking at the reports back from SWED. He was supported by that, by the DNA, which showed no Paul DNA in that area that we're talking about. And then we began going back to the report we got from the Attorney General a few months ago of the final report by Mr. Bevel, who is, by the way, not a forensic chemist. He's not anyway got any scientific degrees. He's a former police officer. And he looks at patterns and determines what they are. And when we looked at that, he said, oh yeah, this is blood spatter. So we then began looking at the SWED reports. What happened after they found out no blood spatter? Well, the chief officer in charge of this case, upon receiving that report, had a Zoom call with Mr. Bevel. And Mr. Bevel said, would you mail me the shirt? And so I can look at it and confirm it can't be tested further. They said, no, we'll bring it to you. He said, no, all the time in federal court, they just mail it, they do a secure mailing. And they had actually offered to mail things to him, mail the shirt to him earlier. That was their offer, not his request. But they felt it was necessary for 2 SLED officers to fly out there. And what Mr. Bevel does, according to what we pieced together, is and by the way, all they have is a picture of the shirt. That's all he had. A picture of the samples in the shirt. And and again, this is outside my wheelhouse, photoshopped the shirt. His statement, photoshopped it to try to accentuate the little points. And in doing that, he now has an opinion it was blood spatter. Now, Your Honor, we're gravely concerned about what happened between the SLED agents and their so-called expert on that trip, and we have no emails, we have no communications between them, we don't know what they discussed, and by the way, there were based on what we read, we believe there are other versions of this report we have not received. So there are other versions, emails, communications. Did they record the Zoom call? I mean, we do that routinely. So we have a record of what this person said or that person said. In addition to that, I think it's telling that in this process of revising this report 180 degrees, that Mr. Bevel relied on this Photoshop process. So one of the things we have made, the motion we filed, is a motion to compel the state to produce evidence regarding alteration of photographs of evidence it destroyed. In other words, they took these photographs. We can't photograph it. It's destroyed. They somehow, in the process of doing the blood test, and again, we've got a hematologist an expert said this is something that chemists, labs, crime labs do every day. The fact they destroyed it is so unusual that it boggles their minds. This is something they do. They can't destroy it testing it for blood because we have a right to test it.
The shirt still exists. Or does it?
The shirt exists, but it is dark purple or black, and there's no way you can see detail of the threads. So it is for forensic purposes, and I think the state is not going to argue you can test it. Mr. Bevel said you can't test it after he saw it, and the experts say you can't test it because it's been ruined. I mean, ruined for forensic purposes. It's whatever chemical treatments they put on it, they did wrong in the sense that it made it unusable after that. Now, Your Honor, so we've made a motion to get, our first motion would be to compel the state to produce evidence regarding alteration of photographs and evidence it destroyed. And there's some very specific things on this Photoshop that we want the native Photoshop documents that they created, used, and then manipulated. We have very specific things we'd like. They exist, and we'd like the state to prove them so that we can see. I mean, prior to this Photoshopping, his opinion was no blood spatter. Then he Photoshops it, and now it is blood spatter. Even though one of the points he finds on the shirt, he says now as part of the blood spatter, is negative, not negative, they exclude Paul Murdaugh as a contributor. So this becomes extremely important. The second thing that's important for us to do is to have an evidentiary hearing where the SLATE folks that conducted the tests, the agents that went and met with Mr. Bevel, produce all their emails, produce all the communications, produce the Zoom if they have it, and any notes they have of those meetings. And if Mr. Bevel has notes of those meetings or emails or other communications, we'd like those too. I mean, Your Honor, this was leaked to the press a year ago that Al Murdaugh had Paul Murdaugh blood spatter, was the shooter because he had blood spatter. That, first of all, SLED will testify there's no blood. So I don't know any have blood spatter. Number two, the DNA spot would exclude Paul. Exclude. And number three, we believe the forensics is going to show that whoever shot Paul Murdaugh and basically blew his head off would be covered in blood, not just spattered. Now, we reached out to Mr. Bevel, wrote him a letter, said, here's the motions we filed. We'd like to talk to you. He got back to us yesterday. Your Honor, if I could hand you a copy. From Mr. Bevel, in which he indicated he'd be I'm sorry, I handed you the wrong email. Let me see what I handed you. This was. No, this is the one I wanted to give you. See? Okay. I think I handed you that. I had two emails. Handed you the wrong one, Your Honor. Your Honor, and what he says is, first, my apologies for not getting back to you sooner. We've been dealing with two deaths in our family a week apart, which put many things on hold. Our company policy is always to honor a request to speak to an attorney about an active case. We always invite the opposing attorney to listen or be present for the interview, and have done so in this case. I've not heard back from possible open dates, but I'll be available when dates are identified. I assume you will allow us to talk to him with you present.
Absolutely, that's what we told him.
Okay. Secondly, Your Honor, we need an evidentiary hearing after we have a chance to talk to Mr. Bevel. We'd like to subpoena all these SLED folks to come testify, but we'd like to get the documents from Mr. Bevel.
The purpose of the hearing will be what?
Pardon?
What's the purpose of the hearing?
The purpose of the hearing, Your Honor, is to develop a basis to determine whether or not we want to make a motion to exclude the shirt. Right now, we think there's lots of stuff here, but we need to understand, for instance, under Chiefborough. Under the Chiefborough case, we not only have to show they destroyed the evidence or altered the evidence, but we have to show it was done in bad faith. And that's why we need to ask what happened. Was it reckless? Was it beyond what's normal? What did they do wrong? And secondly, we can't develop that without talking to these folks at the minimum. And I'd like them under oath when we talk to them. Also on the Photoshop piece, we need to understand how he did it, so that we then can determine whether or not his, now that would be for a counsel hearing at a later date. I don't want a counsel hearing. I just need an evidentiary hearing to determine whether or not we have to hire additional experts.
You want this hearing for me to order them to produce information for us to then have another hearing so that you can then determine whether you're going to file a motion to exclude evidence at trial. Evidence that I don't know will be the state intends to offer or not.
Well, by then, hopefully we'll get I know that the Attorney General is trying to work through this, and in his defense, I don't think he had a lot of this. I know he didn't have a lot of this before we had. Now, why that is, I think he would give you a more benign explanation. But when I see a draft report saying it's not blood spatter hidden in a wrong file, and by the way, they said, at some point they said, we always had it. Again, we're getting a terabyte of data and looking for a needle in that terabyte haystack.
All right. So I understand the motion. I'm going to give Mr. Waters an opportunity to respond to the motion.
So,
You're making the motion.
Yes, Your Honor. Am I done?
Yes, sir. Mr. Waters.
Thank you, Judge, and may it please the court. Your Honor, I, of course, had a conversation with Mr. Harpootlian. I know last Friday y'all were in with the jury in the trial that you were doing, and we had a chance to speak about this and about the motion that he's filed. And I would say that at this point, a ruling from Your Honor, I think, is premature, because what I expressed to Mr. Harpootlian then and what I've expressed here today is that we're in the process of assessing the viability of some of the information that's been gathered and how that affects this report, and ultimately whether or not it is anything the state intends to offer. I've expressed to them as well that I will fully advise them of that particular process and what we uncover and my decision and the reasons for that decision. And then at that time, assuming that there's even any more an issue to be had, that they could then litigate it at the time. What we've found out, unfortunately, is that that November report with the hemotrace was not provided to our office through the normal discovery. And in fact, I did not receive that report until last Wednesday, November the 30th, when I literally was at SLED attempting to figure out our response to the motions after it had been filed, of course, the day before Thanksgiving. I set up a meeting, we went out there, and literally was out there going, what report are we talking about? And that's when the report actually first really came to my attention.
What report are you referring to?
There's a November report, November 2021 report, Your Honor, in which SLED had tested various cuttings from the shirt with hemotrace, which tests for human blood, and they did not identify human blood on those particular samples. And so just to back up a little bit, obviously the Attorney General's office was not involved in this case for the first 3 months. I did not get involved until September of 2021. The case at the time was with the 14th Circuit. In July of 2021, SLED Forensics were looking at various things they could do to test the shirt, and they applied a substance which is very common and commonly used called LCV to the shirt, which can react with blood. And that's what they keep talking about, it being destroyed. It's not destroyed, the shirt is still there. It's just that a consequence of that testing on the shirt is that it then becomes discolored. So it's kind of purple. That's actually what it does, is that you can see the alleged blood on there. During the course of that testing, after they did that, they then, I think subsequent to that, and bear with me, Your Honor, I guess in September, they then reached out to Mr. Bevel, and again, this was SLED doing this, reached out to Mr. Bevel to get him to ultimately review the case. And then that process went forward. The Attorney General's office, we had no involvement in any of the interaction with Bevel. The only involvement that I did actually have during the process of dealing with Mr. Bevel was when they actually called me and said, hey, Mr. Bevel says that we can mail the shirt. And I said, no, you ain't mailing no shirt. This case is too important. I want it always in the custody, direct custody of a law enforcement officer. So that was what I said at that time, but it was more about just the importance of this case and ensuring that a major piece of evidence didn't get lost in the mail or something else happened that would affect the chain of custody and the security of that evidence.
Is it anticipated that Mr. Bevel will be a witness in the case?
Well, and so ultimately, when this report has come to light, the first thing that I did, of course, was talk to the SLED experts and talk to Mr. Bevel. And I said, how do we assess this? Is this, how does this affect the report? Is it going to undermine at least that aspect of the report? Is it going to, the conclusions are still there, but maybe not as strong? Or is it something that we need to not pursue? And obviously, I immediately started to ask SLED to begin that process of determining the effect of that evidence. And that process is ongoing. We had meetings with them yesterday where I sent some of my folks out there to do that, to assess the effect of this hemotrace, and there's a number of factors to consider. There's a number of factors to consider as to the dilution, as to the location, as to possible reaction of LCV to the hemotrace test, in order to determine whether or not there is any significant possibility of a false negative on those tests. And that's exactly what
the answer is yes, no, or you don't know yet.
The answer is that we do not know yet, and that's what I've told Mr. Harpootlian. I told him Friday and today. Mr. Bevel, the email that you just got, unfortunately has been out of pocket, and he was going to do that same process in assessing whether or not the effect of this report on his ultimate conclusion. He unfortunately, because of deaths in the family, has been out of pocket, but as I've told the defense, the second that I get reasoned answers to the science of this, I will assess whether or not what that means to the viability of this evidence. I will, of course, advise the defense, and in the event that we decide that it's still viable in some way or form or fashion, then at that time I think it would be appropriate for them to litigate however they want to litigate the issue. And that's exactly what we're going to do.
What is your response to his motion to compel the communications and all of the other?
We have and are providing every. I'm sorry, I didn't interrupt. We have and we are providing every single thing related to Bevel to the defense, and in fact, again, that's how some of this stuff, has ultimately come to light. So I don't think there's any need for any motion to compel, because anything that we have that's Bevel related, they're going to have, and anything about this process, they're going to have, and reasons for any decision that I make, they're going to have, and then again, they can bring that to your court. They're unsatisfied.
I think the basis for the motion is that they do not currently have it and they want it.
And again, I believe that we've provided every single thing that we have, and there's nothing Bevel related that we are withholding, that we intend to withhold. And again, this is an open book process with the defense. They will understand the reasons for my decision, and they can respond accordingly at that time. But I think it's appropriate that we give time for the scientists to assess the science and to ultimately come up to whatever conclusion that is. They'll advise me of that. I'll advise the defense of that, as well as my decision. It may be that this is a non-issue.
Your Honor, two things. One, I believe they're obligated to give us whatever Mr. Bevel has in addition, and I'm not sure that we've gotten everything from them. And let me say this, we've asked for phone stuff. We got stuff last night, phone records that we asked for 3 months ago. We got a trial 5 weeks from now. And, I don't particularly want to be litigating this over the week before Christmas, the week after Christmas. We've got work to do. So we'd ask Your Honor to order the state to provide us everything Mr. Bevel has, all his notes, any communications he has. Your Honor, let me put this in context for you. Mr. Bevel goes around the country testifying about blood spatter. He testified in Indiana in a case named Cann, C-A-N-N. The jury acquitted the man. He said definitely had the blood spatter of his wife and dead children on him. They did there's a national system to look for DNA, which they state then did. They have not done in this case. And they identified a guy named Boney, arrested him, and convicted him. But for some of the experts we've been talking to questioning Mr. Bevel's art, or it's not a science, that young man would have been convicted and doing life, going to the electric chair. So this is critical because this blood spatter, this guy's not a scientist. He looks at something and gives it sort of a Rorschach test. He had originally looked at it and said, nah, no blood spatter. Then he photoshops it and says, yeah, blood spatter. We need to understand why he changed his mind. And we'd like to, ultimately, we need this evidence to get in a position. We're going to assume that he's going to go forward with it. But we can't wait until he makes his decision to get this information, to begin working, to get ready for, maybe we won't have a hearing, but we need to be ready if we do. And we're 5 weeks out now.
Right. Anything else on this motion? Yes, sir.
Very quickly, Your Honor, a couple things. Number one, I don't have custody or control of Mr. Bevel's notes. He's not a state actor. I do have, and we have provided every communication that I'm aware of between SLED and Mr. Bevel, as well as the drafts and everything else. So I'm not aware of anything outstanding. But Your Honor, we're not going to withhold anything in that regard. Secondly, he mentioned some stuff that was provided yesterday. That was some of the stuff that came from the 14th Circuit, but it is my understanding it's duplicates, so we're providing out of an abundance of caution in that regard. In any event, Your Honor, again, there's nothing I don't believe that is Bevel related that we possess that we have not already provided to the defense. And if I uncover anything else, first people that will get it will be him.
Could I just make two things? There's a PowerPoint referred to in the original Bevel report in which he says no blood spatter. We don't have that. We have very specific information we want on the whatchamacallit he did of the blood spatter, the Photoshop. We need that for our experts to be able to analyze whether or not this is voodoo science or whether this is the real thing. And again, this is a guy who goes around the country doing this and has been wrong in the past. So we need that information.
I've heard enough on the issue,
Yeah.
motions and what's at stake, and I reviewed your motion. I grant the motion to compel you to prepare a proposed order and share it with Mr. Waters, and I'll review it and issue a written order
Thank you, Your Honor.
based on that.
Thank you, Judge.
The next motion.
Yes, sir. The next motion, of course, deals with the bill of particulars as well as the state's alternative motion in limine for admission of evidence as to the various exceptions under 404B, such as motive, intent, common scheme or plan, identity. And we had a conversation again last Friday about that, and ultimately discussed the fact that they would file a bill of particulars, to which we responded. We ultimately, in our response, object procedurally to the bill of particulars as not a viable procedural mechanism under South Carolina law, but take the position, alternatively, though, that this is an issue that we need to assess with the court as we move forward because of how important it is to the case. And, of course, file a detailed response that Your Honor would have yesterday. And the reason for that is, Your Honor, is that in this particular case, where you have a man who was accused and indicted for the murder of his own wife and son, that motive might be the most important fact that any jury would want to know. It's not an element of the offense, but it is the most important fact that any jury is going to want to know in this case. And for a jury to understand that, for them to really understand what the motive is in this particular case, they're going to have to understand that there was a huge difference between who Alec Murdaugh professed to be to the outside world and how important that was to him as a central figure in this prominent family, and who he really was, that only he knew, that no one else knew. Over and over again, I've interviewed witnesses or put witnesses on the stand and who thought that they knew this man, and they over and over again said, I didn't know him. I didn't know who this man was. And so for a jury to understand that, they're going to have to understand not only that distinction between who he professed to be and who he was and how important that was to him, but also how that allowed him to avoid accountability for defrauding victims of almost $9 million since 2011 that we've been able to detect. I think when this case started, a lot of people assumed that this was a murder case, and then a few months later, there was some white collar thrown in there. But the reality is we have done this extensive investigation, state grand jury investigation. We've realized that this is a white collar case that culminated with 2 murders. And so if you look at the development of this particular case and the evidence in this particular case, what we see is that the defendant in the late 2000s, and that's a long time to go back, and I recognize that, Your Honor, but I think the important point to realize is that this is an unbroken chain of constant lies and misappropriations and thefts that has been going on for so long. A hamster wheel on which this man has been on constantly, having to borrow, to earn, to steal millions of dollars just to keep kicking the can down the road and staying above water. An exhausting hamster wheel. A slow burn that was heating up until June the 7th, 2021. And it all started with some land deals in 2008, 2007, 2008. The recession hit, and he really ended up upside down on those land deals. And it materially changed his financial picture. The reason why we know that, Your Honor, is that in early part of this past decade, in 2011, he had some big cases. He had the Pinckney case. He had the Thomas case. He had the Badger case. And these cases, the people around him thought, they knew he had some issues and had some problems, but they thought that those recoveries and those really high fees that he had obtained, 6 figures or more, had fixed the financial problems that Murdaugh had. But they didn't. They weren't enough. And not only did he have huge fees from those particular cases, but he also stole money from the clients as well. Your Honor, if I look at the unbroken chain that I'm talking about here of these thefts that went on, they start in 2011. And every single year from 2011 to 2021, he stole money from clients. It is an unbroken chain because even though he was making 6 and sometimes 7 figures of legitimate income in his law practice, it was not enough to sustain the lifestyle that he had and the debts that he had. Even though he was borrowing millions of dollars from Palmetto State Bank, from his buddy Russell Lafitte, borrowing close to $1 million from his law partner, borrowing hundreds of thousands of dollars from his father, borrowing hundreds of thousands of dollars from Russell Lafitte's father, having Russell Lafitte loan him close to $1 million from the Plyler money, for which he had Russell appointed conservator. It still wasn't enough. It wasn't enough to keep Murdaugh's head above water. And it couldn't stop. It couldn't stop. I've detailed in the filing, and Your Honor is generally familiar with the state grand jury evidence of the 4 manners in which he was stealing money, including from his own family and his law firm. And he had been doing that for a long time. But one thing happened that caused the slow burn to finally heat up. And that was the boat case in February of 2019. Your Honor, I've done a lot of white-collar crime, and like every Ponzi scheme, theoretically a Ponzi can last forever as long as there's new money. But the second that money stops or slows down, it's inevitably going to crash and burn. And that is what the boat case meant here. That is what the boat case meant here. And so what we see after the boat case is we see a huge uptick in the amount of money that he is stealing. And the biggest one of that is the Satterfields. And that one's different because he's actually the defendant in that particular case. He's not the plaintiff's attorney there. And what he does is conspire with his buddy, Corey Fleming, to get a recovery against his own insurance company for her fall at his house. And then has Corey Fleming write the check out to the fake forge account. $2.9 million. And unlike prior to the boat case, where he's able to pull off a sleight of hand of stealing money from clients in plain sight with stuff on the disbursement forms and the sheets that they're signing, because at the same time he's handing them a huge check of life-changing money, and they're shaking his hand as they walk out the door. Here, with the Satterfields, after the boat case, he takes it all. He takes every dime. Every dime. What does that mean? Well, one thing it means is that he doesn't have that umbrella policy anymore. And so the boat case becomes very significant because the plaintiffs in the boat case made it very clear that this was not just about recovering from an insurance company or recovering from the deep pockets of the convenience store or the bar. The plaintiffs wanted a specific personal recovery from Alec Murdaugh because they believed, like everyone, that he had a lot of money. And it was the principle of the thing that they wanted him to pay personally if there was going to be any settlement. And as that time went on, the boat case plaintiffs made it very clear to Alec Murdaugh's civil attorneys that we want a personal recovery from Alec Murdaugh. And they finally, his attorneys finally tell them, and they say, he doesn't have any money. And they're incredulous. They don't believe that because, like everyone, they believe he's very wealthy. And they file a motion to compel, to disclose his accounts, to disclose his finances, disclose all of that. And that hearing is initially set for May of 2021, but it gets continued because Mr. Murdaugh's attorney, John Tiller, who's of course deceased now, was having medical treatments. What else is going on at this time as we're in now the spring of 2021? Well, state grand jury subpoenas are being issued as well about the boat case out in Hampton and Colleton counties. And what else is going on at this particular time? Alec Murdaugh has an opportunity for a big recovery in a case he has with Chris Wilson. And he actually argues and agrees to get the defendants, who were a big automotive company, and he gets them to agree to what seemed like a really good move at the time. He gets them to say he's going to waive punitive damages if they waive the right to appeal. So that it's going to be bench tried, and so whatever decision is made, bench tried on just damages, then that money is going to be instantly available. That might seem like a good strategic move, but the reality is that Alec Murdaugh needs that money right now. Because the way the law firm worked is that you don't get your bonus until the end of the year. And other than that, you just get a $125,000 salary spread out over the course of the year. For a person that the second he gets an infusion of cash, high six figures, it's gone within months. So that case happens. The judge issues his ruling, and ultimately it's a pretty good recovery, and there's $792,000 in fees for Mr. Murdaugh. But what he does is he convinces his co-counsel in that case to write those fees directly to him instead of writing it to the firm. And why is that? So that he can get that money right away and bypass the firm where it's supposed to go. And so he does that, $750,000, and it's gone within a very, very short period of time. In May of 2021, though, his staff, Mr. Murdaugh's staff, becomes suspicious because they get the expense check and they don't have the fee check. And they call up the other attorney's office and they say, "Where's the fees?" And initially, apparently, he was like, "Well, we gave it to Ellen." And then they're trying to figure it out and they can't get a satisfactory answer. And they go up and talk to financial staff and they're trying to get a straight answer and they can't get a straight answer. And one of the attorneys calls that other attorney and they can't seem to figure it out. Where are these fees? Where is $792,000 in fees? He's already gotten it. He's already spent it. He doesn't have the means to pay it back. So what happens on June 10th? All of this is finally coming to a head. That morning, a PMPED staffer comes in the office at the direction of the partners and says, Alec, I need an answer today. Where is that money? I need an answer today. And Alec is in his office working on the boat case because that hearing is scheduled for June 10th. And Judge Hall has made it very clear there's going to be no more continuances. And that's going to expose everything as well. And the only thing that stops the conversation about I need an answer right now is that Alec, unfortunately, gets a call that Mr. Randolph had gone into the hospital with a very poor prognosis. His father, who repeatedly had loaned him hundreds of thousands of dollars when he needed it. All of those are happening on this very day. It's a day of reckoning for him. The very day that Maggie and Paul were murdered. And what happens in the wake of that? What happens is the exact opposite happens. Everybody immediately rallies to his aid. Immediately that hearing is canceled. It's not even rescheduled anytime soon. The PMPED people that would be, the last thing they're worried about is where these fees are. They don't care about that anymore. They're all rallying to his aid. All of the things that were about to happen stop. And what does he do in the interim? The first thing he does, one of the first things he does, at least business-wise, is get more money from one of his law partners, get more money from Russell Lafitte from Palmetto State Bank in order to send enough money to Chris Wilson that Chris Wilson will then send it to PMPED and say, yeah, those fees were there the whole time. Everything's cool. He covers his tracks. And that would have never happened if it wasn't for the deaths of Maggie and Paul. It would have never happened. And the only thing that changed was that in September, a PMPED staffer happened to find a copy of the check that was written from the other lawyer directly made out to Alec. And she knew right then that he had been lying about it. And she takes it to another staffer, and that triggers another staffer to think about some other forged checks that had been made out that didn't seem quite right. And they go look at those checks, and then they run it through the system, and all of a sudden all the forged checks start popping up. And they go and take it to the partners, and they're like, oh my God, he's been stealing from us. He's been stealing from clients. And they eventually confront him, and he resigns. That's September 3rd. September 4th, his best friend, who he had convinced to send back those fees to PMPED, but to cover $192,000 with his own money that Alec couldn't borrow enough to pay, is trying to get a hold of him and finally gets to meet with him on the doorstep or on the front porch of Alec's mother's house. And Alec confesses to him that he's been using pills and that he's been stealing and he doesn't have the $192,000. All that accountability is starting to crash down on Alec again. And what happens? Within a couple of hours of that conversation with his best friend confronting him about the $192,000, Alec is the victim on the side of the road. And instantly everybody rallies to his aid again. Accountability is coming on him, and suddenly there's a gunshot and he's a victim again. And everybody rushes to his aid again, except this time it doesn't take long for people to figure out that something's not right here. but the symmetry there is very, very telling. Your Honor, this is an unbroken chain of financial crimes that highlight what has happened here. This is a white-collar case that culminated in murders, and we've cited a number of cases in here of very, very similar circumstances in which courts have admitted evidence of motive just like this. And I would actually point to one case that we cited, and this is the Siegel case. And this was written, I believe, by Judge Traxler on the Fourth Circuit. And there's a number of cases that we cited in our brief. And this is a quote from that particular case. Because Siegel had been defrauding multiple victims for the last at least 20 years and had never taken such extreme action, it is particularly important for the government to be able to explain to the jury why it was suddenly necessary for Siegel to resort to murder. This is not propensity evidence. Evidence of all this fraud and abuse of his law license is not propensity evidence. It doesn't show that he's more likely to engage in fraud, because murder is a much different thing than fraud. But what it does show is what may be the most important fact in this entire case, and that is why this particular individual would murder his own wife and son. And the answer is because it allowed him to escape the accountability that was coming upon him that he's never had to deal with in his entire life. Never had to deal with it in his entire life. And it worked. It worked. And if it wasn't for that check showing up in September, it might be still working to this day. I think the case law is clear, Your Honor, that this is admissible evidence. In this particular case, because of how important motive is and how singularly important it is to the jury, particularly when you have an individual accused of killing his own family members, where there's typically an affectionate relationship, the probative value far outweighs any prejudicial effect. And I would also point out that all of this is established by more than clear and convincing evidence, which is part of the standard as well. All of this, the vast majority of it, is the subject of state grand jury indictments, the subject of evidence that's been gathered by subpoena, sworn testimony, and it's already out there in all of these indictments. So the prejudicial effect is minimal, but the probative value is extreme in explaining what led this to happen. And that was that the day of reckoning was upon him, and he was out of cards to play after he's been playing every card he could for 10 years. Thank you, Judge.
Mr. Griffin?
Yeah, Your Honor, I thought we were going to argue these motions in the order that they were filed. I filed our motion for bill of particulars, but I didn't interrupt Mr. Waters because, frankly, the things that he was saying really conformed to our request for a bill of particulars. And the reason that we had asked for a bill of particulars is because, as Your Honor knows, that character evidence, evidence of bad acts, other criminal conduct is not admissible in a criminal trial to prove that the person is a bad person, that the person is a criminal, that the person probably committed this crime because of his bad character and his bad behavior. And, Your Honor, the first 10 minutes of Mr. Waters' argument and the first page of his memo goes to exactly that. The first page of his memo says, to properly evaluate motive, the jury will need to understand the distinction between who Alex Murdaugh appeared to be to the outside world, a successful lawyer and scion of the most prominent family in the region, and who he was in real life. Only he fully knew an alleged crooked lawyer and drug user who borrowed money and stole wherever he could to stay afloat. He's a bad guy, Judge. Jury needs to know he's a bad dude. And because he's a bad dude, we wouldn't put it past him to kill his wife and son. And that is the exact reason that we have Rule 404B and our rules of evidence. in South Carolina, we're lucky that we have the seminal case of State v. Lyle that is cited all around the country, and it's essentially precursor to the federal rule 404B and our rules of 404B. And I just would like to quote a little bit from State v. Lyle, and it points to the reason that this character evidence of other criminal conduct is not admissible generally, and it says proof that a defendant has been guilty of another crime equally heinous prompts to a ready acceptance of and belief in the prosecution's theory that he is guilty of the crime charged. Its effect is to predispose the mind of the juror to believe that the prisoner guilty, and thus effectively strips him of the presumption of innocence. Now, the State v. Lyle and our rules have developed, and there are exceptions. One is motive. But State v. Lyle is very instructive on the level of proof you have to make to get to the exception. And I'll just quote, the acid test to get to the exception is its logical relevancy to the particular accepted purpose or purposes for which it's sought to be introduced. Lyle goes on to say, the dangerous tendency and misleading probative force of this class of evidence of other crimes, require that its admission be subject to the courts to rigid scrutiny. And concluding in Lyle, it says, hence, if the court does not clearly perceive the connection between the extraneous criminal transaction and the crime charged, that is its logical relevancy, the accused should be given the benefit of the doubt and the evidence should be rejected. That's State v. Lyle. And so, Your Honor, in their response to our motion for bill of particulars, they say, we've known all of this since we had it available since January of 2022, that he's been charged in 18 indictments, over 90 separate counts, and we've been given discovery on that. And all that is true. And we have all that. And it's a universe of information, and he gave a great opening, closing, whatever argument he wants to give to the jury to point and paint Mr. Murdaugh as a bad guy. But the most important part of our motion for bill of particulars was to identify that universe of evidence you intend to offer at trial, and how is it relevant? How does it meet the acid test of logical relevancy to the particular exception? Here, motive.
What page is that on your motion?
On my motion.
Motion for bill of particulars.
Well, I'm responding to his argument, Your Honor, but in our motion for bill of particulars.
I thought you were citing from your motion that you're...
No, sir. I was not. I was reading from State v. Lyle.
All right.
Acid test.
Okay.
But we did ask in the bill of particulars to tell us what your motive is, what your theory of motive is, and they had a 20.
Isn't that what he just did?
He did, and we're frankly satisfied with that. We've gotten what we want. Now what he did last night, well, Wednesday night at 11:55, he sent us an unfiled response and his own motion in limine asking for this court to rule that all of that universe of information is admissible. And frankly, Your Honor, we haven't had an opportunity to fully respond to that. I'm here to respond to his arguments on that, but we would like an opportunity to fully brief what they have, their motion that they filed and we got yesterday.
So, and I understand that, as I indicated, we would take the motions in the order filed, and the motion for bill of particulars was the second motion filed, I believe. Mr. Waters started arguing number 4, which is his motion to eliminate.
Right.
And it's all combined now with your motion for bill of particulars. Are you still, what do you want me to do with this motion for bill of particulars?
Your Honor, we're satisfied if his response is that's what they intend to introduce and that's their theory of motive, and he puts on the record we're satisfied with our bill of particulars, because we have asked, and now we have heard what the connection is, what their theory of motive is, and I'm happy to address his arguments and why that theory of motive that's on page 13 to shift focus away from himself and buy additional time to try and prevent financial crimes from being uncovered, how that's unprecedented. There's never a case you would find that says that is the logical, that meets the acid test of logical relevancy. I mean, so what
Let me address your motion for bill of particulars. When I started practicing law 48 years ago now, in the state of Ohio, it was routine to file a motion for bill of particulars. Every defendant would file that routinely, and the state had to file a response. That's Ohio. Now South Carolina, and in the state's response, that's not a motion that's recognized by this state. Do you agree with that?
it's not standard, Your Honor. I think the court has the authority to order it.
You all cited some cases from maybe 1830 or back in slavery time and beyond. But it's not a motion that is recognized under current South Carolina jurisprudence. Now, in response, the state has outlined what they would like to offer as far as evidence in support of motive in response to your motion for bill of particulars. Having responded in the manner the state has, then it renders the motion for bill of particulars moot, basically, the motion. So I want the record to be clear. I am not trying to set a precedent in South Carolina for lawyers in every case to file a motion for bill of particulars because it's not recognized under South Carolina law. So you are, in effect, we're deeming this motion to be moot and based on the state's response. So that deals, in effect, with the motion number 2, not necessarily with Mr. Waters' counter motion, which he included in response to your motion for bill of particulars.
Yes.
Now, that takes care of number 2.
Well, Mr. Harpootlian combined the first motion was for the motion about the sheriff. The second motion was motion to compel the discovery. The third motion was the motion to unshackle Mr. Murdaugh, which he is unshackled here in the courtroom, and we appreciate that. I think that's...
Is there anything else we need to address on that issue?
No, Your Honor.
Your Honor, just for clarity of the record, obviously we filed a response. I'm well aware of the case law out there, and I'm not going to spike this case with an appellate issue, which generally says that a defendant should not be shackled in front of the jury. As always, if specific security issues arise that are expressed to me by law enforcement or the SLED agents responsible for his security, I will, of course, make that aware to the court for a decision at that time.
All right, well, the defense has certainly done a lot of research and cited my own case from 2008 or whatever year that was, addressing the issue of defendants not being shackled, and that was a death penalty case. So defendants generally just are not shackled or should never be shackled in the presence of the jury. This motion goes beyond that to address not solely before a jury, but before the media, in effect. I agree with that motion to the extent that the defendant should not be put in a position where he visibly appears to be shackled, that could be projected out to potential jurors in this case. And I've sent word to law enforcement that they need to address that issue so that that appearance won't be given. So that issue is being addressed.
Thank you, Your Honor.
So that's that motion.
And yes, sir. And then the fourth motion would be their counter motion to our bill of particulars that, Your Honor, we just frankly got yesterday. He's argued it. I would like to respond to his argument, but we would like an opportunity to further brief it since we just got it yesterday.
Mr. Waters.
Thank you, Your Honor. Very quickly, in response to some of the presentation from Mr. Griffin, he talks about the acid test.
I haven't finished. I've not finished my response.
Happy to see.
Yeah, the question is, should you need to respond since you're having an opportunity to digest it, research it, and prepare a complete response? And of course, the other question is, a motion, in effect, it's a motion in limine by the state for me to order evidence to be admissible,
Yes, sir.
which is sort of the reverse from the way motions in limine are typically utilized. It's generally to exclude evidence, not to include evidence. But you need time to respond to that, and that's certainly understandable. It came in late yesterday.
And Your Honor, again, I would just say that when we just talked Friday, when you were in with the jury, that was kind of what we discussed. They were going to file the bill of particulars, I'd respond, and then we were asked for this hearing here today. So that was my understanding as we were here to argue on that. That's fine if they need some more time. I would, though, like to have a quick opportunity to respond at the appropriate time to some of the points that he just made, very briefly.
Okay, sure.
If I could, just 5 minutes, Your Honor. Maybe 7 minutes. But on page 13, they do identify their theory of motive, which is essentially he's trying to shift focus away from a potential financial investigation to himself. So therefore, he murders his wife and son to avoid scrutiny and puts himself in the middle of a murder investigation. As the person who finds the victims of murder. And as SLED will say, and they've said over and over, when you investigate murders, you start from the circle and you work your way out. And so their theory is to take himself away from being scrutinized in financial misdealings, he puts himself in the middle of a murder investigation. The case law dealing with admissible evidence pertaining to financial crimes in a murder fall into a couple of categories. One is, and really it comes down to 2 points. One, they either kill the victim to avoid the victim disclosing their misconduct. Either the victim is the victim of the financial crime itself, or the victim is a witness or has some other ability to alert law enforcement or authorities of these financial crimes. That's number one. And the Stiegel case, Your Honor, that he cited, it's a federal...
Spell that word for me so we can...
I'm sorry, Siegel, S-I-E-G-E-L. That's at 536 F 3rd 306. This is 4th Circuit opinion. And the defendant in the Siegel case was charged with violating Title 18 United States Code, Section 1512, which requires the government to prove not only the defendant killed the victim, but killed the victim for purposes of preventing him or anyone else from providing law enforcement with information about federal crimes. And so the federal crimes in the Siegel case were the financial crimes. And so that falls squarely within a logical motive, why it's relevant, and why it would meet the acid test. The other grounds is if the murdering of the victim, it causes a financial windfall or benefit to the defendant, so that the defendant can gain money in order to work himself or herself out of the financial predicament they're in.
So you're distinguishing that from the state's theory and allegations in this case?
Yes. I'm telling you, Your Honor, the case law they cited, case law that we've looked at and that we submit to the court, those are the two canons of motive evidence in murder cases where you get financial crimes in. It's either by killing the victim, they get a financial windfall, or by killing the victim, they prevent the victim from reporting their financial crimes. And what we don't have here in this case, Your Honor, there's no evidence that Alec Murdaugh would have reaped any financial benefit from murdering Paul and Maggie. There's no evidence of any life insurance, No evidence of any life insurance whatsoever. No evidence of anything like that. There's no evidence that Maggie or Paul knew of any alleged financial improprieties involving Alec. They don't put it in here, and then frankly, it does not exist in any of the terabytes of information we've received. You know, we've read in the press over years that Maggie had hired a forensic accountant. Didn't happen. No evidence of it. It's not in the case that that Maggie and Alec were having marital problems, and that there was an impending divorce, and that would have disclosed his financial house of cards. Not true. Didn't happen. Not in the case. And there's no evidence whatsoever that Maggie and Paul were a risk to Alec to disclose anything relating to any financial misdeeds. Then there's this issue of he did it to engender sympathy and to distract. And as Your Honor, and he said on June 7th, Randolph Murdaugh, his father, was put back in the hospital to die, who did die 2 days later. I mean, if this was about sympathy, he had all the sympathy coming to him from the firm and the community, losing his father. So there's really no logical relevance that meets the acid test that this court has to determine. Doesn't meet the acid test that it is it's logically relevant. There's just no case law to support it. We would certainly further brief that. There's other points that we may not like to address. First is this: there's a day of reckoning coming on June 10th because there's a motion to compel in the voting action case. As Your Honor knows, experienced civil trial judge as well as criminal trial judge. That motion was to get Mr. Murdaugh's financial information for purposes of punitive damages. And the extent of what would have been ordered in a practical, in most every case, is a financial statement. And in fact, the evidence is that Mr. Murdaugh had handwritten out a financial statement for purposes of that hearing. All he had to do was produce a financial statement, a statement of net worth. And as Your Honor knows, that there's no doomsday reckoning in that regard in a civil case. The other issue that he raises, the state grand jury is issuing subpoenas for public corruption or something in connection with the voting action case. There's no evidence that Alec Murdaugh knew of those subpoenas. No evidence I don't even know if we've been provided those subpoenas, Your Honor. So, I mean, they're throwing something out there without any connection. And then, Your Honor, and that's, you can't, and part of our bill of particulars was asking for what specific evidence do you intend to introduce? And his answer is everything. Well, so it's not an all or nothing proposition either, Your Honor. He was confronted as the evidence that they intend to present on June 7th by a bookkeeper in the law firm about where's this fee money. This was fee money. This wasn't client settlement proceed money. It wasn't lien money that should go to a third-party health care provider. This was attorney's fee within the firm. And he was questioned about that. He got a call that his father was going back into the hospital. And so they want to bootstrap that one conversation into introducing evidence of 20 years of financial fraud, a chain of events, a hamster on a wheel of financial fraud, because he had one conversation about one transaction. And Your Honor, that is certainly, if the court is going to allow anything relating to that, it should be limited to that, not open the door for 20 years of alleged financial irregularities. And then, lastly, Your Honor, the shooting on the side of the road, this happened after the murder. And, they filed, in their motion, they've asked that you go ahead and rule that is admissible in this case at trial. But his explanation of the shooting on the side of the road is he was distraught over being confronted by the law firm over financial misdealings. He resigned from the law firm that day, and the shooting was in relation to his exposure by the law firm of alleged financial irregularities. And it happened after the murder, had nothing to do with the murder, and it certainly should not be admissible. So, Your Honor, that's sort of a 30,000-foot view of our argument, and we would follow it up with a brief with case law.
We're going to take a 5-minute break, 5-minute recess before hearing back from the state. Thank you.
Thank you, Judge.
So it'll be up I'm gonna hand some of these I'm not letting you that's what you you're gonna see I counted last week. It's big. I counted last week. And when you get back, I'm gonna talk to you about my lunch and that's the I have to get his card out.
Yeah.
Squatter, yes, sir.
Thank you, Your Honor. Very briefly, because I understand that we'll probably return at some point to argue this in more detail, but I do just want to respond to some of the contentions from the defense. And, the first one is, and I have the cases, and we've cited them in there, I'm not going to read them all, but they all very specifically talk about how motive is a specifically, and one of them, maybe the most specifically recognized exceptions to 404B, and how particularly important it is in a case. And Your Honor, again, we would assert it's especially important in this case. But one thing I didn't mention before that I do want to mention, when we talk about the acid test of Lyle, and what that really refers to is that logical connection. And I think I heard Mr. Griffin even say, okay, he's identified the connection. But let's talk about that logical connection. Within 30 seconds of the first deputy who arrived on the scene on the night of June 7th, 2021, Alec Murdaugh said, "My son's been involved in this boat case. I know that's what it is." He, within 30 seconds of a deputy arriving, starts talking about the boat case. He made it immediately relevant. And then if you start to walk that logical connection back, how do you explain what that means? What is the boat case without explaining what the boat case is? And then how do you explain how that can matter to him so much if you don't start walking back what all that means to his status and his finances, and more importantly, to uncovering or protecting him from being uncovered who he really was? He says in my motion that I just want to show that he's a bad guy. And that's not the case. And the case law is very clear about that, that if it's evidence of motive, the fact that it also shows the existence of another crime does not make it an invisible, if it is valid evidence of motive. He tries to distinguish the cases that we've cited talking about long-standing financial crimes as being the motive for a murder, and said, well, in those cases, he was trying to kill the victim of those financial crimes before they just outed the defendant. Well, it's the same thing here, Your Honor. It's just this case is different. This case is unique. This case is more complex. He's still trying to prevent who he really is from being outed. But unlike those cases where you had a specific victim who had been victimized who was going to testify in court and you could just kill them, he can't kill everybody. He can't kill 11 years worth of victims. He can't do that. But what he does do is kill his wife and son, who were liabilities in the boat case. And immediately it stops everything. Immediately it stops that day of reckoning. Immediately he no longer has to answer that question about those fees. That if it failed to be answered was going to lead the firm to do exactly what they ended up doing 3 months later and uncovering it all. It's the same thing. It's the same thing. It prevents detection. And the reason why, if you look at the first page of my motion, the reason why who he projected to the world and who he really was is not there just to show that he's a bad guy. It's there to show how different those things were and how important they were to him to stop this person from ever being exposed. That's what's important to show, the difference between those two. And how important that was to him, a man who had never faced accountability in his life. He had to protect his reputation. Your Honor, another thing that Mr. Griffin referred to is some of the language that talks about crimes not being that are equally heinous. And again, I said this point earlier, and I want to come back to that, is that we're talking about a number of financial crimes and a murder, okay? This is not propensity evidence that because of the financial crimes and the murder. There's a logical connection, though, that we've talked about of 11 years of that slow burn finally coming to a head. And that's precisely what these cases talk about when they talk about motive being relevant to show why someone might do something that is foreign to any rational person. And this case has that more than any other I think I've ever seen. Thank you, Judge.
Anything further?
No, Your Honor.
the state's response, I see, was filed at 11:52 p.m. on December 7th, or sent to us at that time. It filed yesterday at 9:10. So very, very little time for the court or for the defense to review the filing of the state. Certainly the citation state, United States versus Siegel, which I understand was authored by Judge Traxler,
Yes, sir.
former South Carolina state solicitor and well-respected jurist. We certainly want to review his case among others cited, and anything cited by the defense in the response. As I indicated, this is a reverse motion in limine, basically for the court to make a preliminary ruling on the admissibility of how many years?
About a decade.
A decade of acts. So that's, the court proceeds cautiously in all instances regarding motions in limine because of listening to the arguments. But arguments are not evidence, and lawyers don't testify. So all of this will be reviewed and scrutinized by the court, and appropriate rulings will be made at the appropriate time, but certainly the defense is entitled to have an opportunity to respond. We'll point out, however, that any ruling on any issue can't be based solely on other cases. Each case is unique, and rulings must be fashioned according to the particulars of a certain case, of given cases, not just we don't expect whatever occurred in Siegel, the case of 2008, to be exactly the same facts. Each case had facts in each case generally would be unique. So we'll look to receive the response by the state, and we'll address those issues later. Anything else?
Nothing from the state, Your Honor.
Your Honor, when would you like us to respond?
When would you like to respond?
Never, but if that's not an option, we are coming up on pushing your right.
Yeah. Which is Christmas, 21st. Well, that's just another thing, so.
The 16th, Your Honor, close the business 16th. We can do that.
Mr. Waters? How's that sound to you?
That sounds fine, Your Honor.
And Your Honor, we could email it to you and the state with the idea that we mail it to the corporate court. It's difficult to get stuff filed down here unless you walk it into the court or mail it. I mean, that's the nature of it. Since the Supreme Court seems it not to have electronic filing of criminal cases. If we could get it to you and to the Attorney General on that day, but we put it in the mail to the clerk's office. I would appreciate it.
No objection from the state as long as we get content, Your Honor.
Okay, fine. And concerning the proposed order on the motion to compel?
Sure.
Proposed order on the granting of the motion to compel.
So we need to share that with the Attorney General before we send it to you, Your Honor. Is that correct?
Well, and send it to me and to the Attorney General simultaneously, and I will await any comment by the Attorney General.
We can have it to you next Wednesday, Your Honor.
All right.
Or sooner.
Your Honor, we certainly would request, a week as well, so by close of business or by, on the 23rd, or by 23rd. They were advising me the office may be closed, but that's not going to stop us from working on this on the horizon.
All right, very good. One additional issue. It's been pointed out that Mr. Murdaugh's grandfather's portrait hangs in the courtroom. Discussed the issue with the clerk as to whether it should be removed for the purposes of this trial.
We have no objection.
Leave it to the court's discretion, Your Honor.
And though clerks are typically in charge of the courthouse grounds, and she indicated that she preferred a court order to that effect, but there's no objection, so that will be done. There's precedent for it in the state of Virginia where the judge ordered removal of portraits for certain trials, so it's not without precedent.
But Your Honor, we can stand.
Yes, sir. All right. Very good. So ordered. Anything further today?
Nothing today.
Nothing from the defendant, Your Honor.
Very well. Court will be adjourned.
Thank you, Your Honor.
Very good.